Laws are everywhere and affect most things we do. Most of the time we don't even think about them, and we only become aware when we are breaking the laws. But who decides what is or isn't a law, and how exactly is law made? There are two sources of law in Australia: statute law and common law. Statute law is the type that most people think of when anyone mentions law. It's the type that's written into legislation. The Discrimination Act or Fair Work Act are examples. And these types of laws start with an idea. Ideas can come from pretty much anywhere: campaigns, petitions by the public, parliamentary inquiries, ministerial advisors, or even the media.
My dear Senator, have you the faintest idea what it takes to get a bill passed?
No, you're going to help me. Well, laws affect all of us. They affect our rights and our liberties, and it's important that any new proposal is thoroughly scrutinised. So that's why you have all us parliamentarians scrutinising those laws, often with the assistance of outside experts, with advisors, with parliamentary committees, to make sure that when the law is enacted, it's been thoroughly examined and represents the best outcome.
Statute law is made at both a federal and a state level, which is why there are certain laws that apply to all of Australia and some that vary state to state. For example, some roads in the Northern Territory have no speed limit. And in New South Wales, there's a law that says you can't splash mud on bus passengers on the side of the street. The other source of law is common law, and this is a more confusing concept. It means the body of law that is made by judges and decisions in courts. This type of law sort of fills in the gaps between statute law. It's about interpretation of statutes, and it can change over time.
The common law is the system of English judges in explaining the fair and just solutions to particular problems, and then you get a new case with new facts and slightly different circumstances, and the question becomes, do the old principles in the older case fit the new circumstances? And if not, how do they have to change and how do they have to adapt? The fascinating feature of the common law is that it is constantly evolving. You've got to think of it as like an amoeba that keeps creeping and crawling out of the receptacles.
Common law is also known as judge-made law. It develops when a legal situation arises in court that's not specifically dealt with or laid out in legislation. The judge must decide how the legislation should apply to that set of facts. And the reasoning and the way in which that case is decided sets a precedent for judges to follow in similar situations or in future cases. Precedents are the foundation of common law. There's an old saying that law is black and white, but that's really not the case. I mean, why else would we need lawyers and courts? It's also why people who spend years studying the law to become lawyers often can't give you a 100% definitive answer to your legal issue, because it can be hard to predict how a judge will interpret the law in your case. Laws can be interpreted in different ways, and there are infinite different situations where they can be applied. Sometimes it's just a matter of crossing each bridge when you get to it.